You people never learn, do you? Judge Harlan Greer said it without looking up from his paperwork. He said it the way a man swats a fly, reflexively, without thought, because the fly had never once swatted back. The woman standing at the defendant's table didn't move, didn't blink. Her name was Vera Odom, and she was wearing a navy blue blazer that had been ironed so many times the lapels had started to fray at the corners. She held a manila folder against her chest like a shield, and she looked at Judge Greer the way a person looks at a storm coming in from the west. Calmly, with full knowledge of what it means. The courtroom of Division 7, Harris County Civil Court, smelled like old carpet and fluorescent light, and the specific desperation of people who had no other options. The docket, that Thursday morning, was 32 cases long. Greer had already disposed of 11 of them before 10 o'clock, most in under 4 minutes each. He didn't read the filings. He skimmed them. He ruled with the confidence of a man who had never once been wrong, because no one had ever been in a position to tell him otherwise. At 61, Harlan Greer was a product of his own mythology. He had been appointed to the Harris County bench 19 years ago by a governor who owed his father a favor, a fact Greer had never publicly acknowledged and privately considered irrelevant, because by now, he believed, he had more than earned the seat through sheer force of personality. His rulings were famously blunt. His courtroom was famously quiet. People who came before him unrepresented, people without lawyers, without money, without the vocabulary that the system demanded, left his courtroom with their heads down, whether they deserved to or not. He liked it that way. Order, he called it. Efficiency. Vera Odom had driven 40 minutes from the east side to get here. She had taken the day off from her job at the school district, where she worked as a building facilities coordinator, a title that meant she fixed things, managed contractors, kept a campus of 900 students running without anyone noticing all the ways it could fall apart. She had worn her good blazer. She had printed her documents at the public library the night before, organized them in a tabbed folder, and read the relevant sections of the Texas Property Code 3 times, until she could recite the key provisions from memory. She was here for her mother. Dolores Odom was 74 years old, and had lived in the same house in the 3rd Ward for 41 years. 6 months ago, a property management company called Pinnacle Asset Solutions had purchased the vacant lot adjacent to her home and begun construction on a mixed-use development. During the excavation, their contractors had damaged the shared drainage easement, flooding Dolores's backyard twice in heavy rain, buckling her foundation, and cracking the rear wall of a house she had paid off with 30 years of substitute teaching and cleaning other people's offices on weekends. Pinnacle's lawyers had sent a letter. It said the damage was coincidental. It said the flooding was consistent with regional weather patterns. It said Dolores Odom had 30 days to submit a written rebuttal, or the matter would be considered resolved. Dolores couldn't afford a lawyer, so Vera came instead. State your name and your relation to the defendant, the clerk called. Vera Odom. I'm here on behalf of my mother, Dolores Odom, the plaintiff, not the defendant. We are the ones bringing the claim. Judge Greer looked up for the first time. He took in Vera the way people take in furniture, assessing function, assigning value, moving on. His eyes settled on the fraying blazer, on the public library printouts visible through the thin cover of her folder, on the absence of a second chair at her table, which meant no attorney was coming. He leaned back. Miss Odom, he said, and the way he said it carried everything. The slight pause before the name, the drop in register, the specific boredom of a man performing patience he didn't feel. Are you a licensed attorney? No, Your Honor. I'm representing my mother pro se under Texas Rule of Civil Procedure 7. I know what Rule 7 says. He picked up a pen and turned it end over end between his fingers. What I'm wondering is whether you know what it means to actually be in a courtroom. This isn't a complaint department. This isn't a town hall. You don't get to walk in here with a stack of papers from the internet and call it a legal argument. At the plaintiff's table across the aisle, the attorney for Pinnacle Asset Solutions, a man named Foster, whose suit cost more than Vera's monthly mortgage payment, allowed himself a small smile. He had seen this before. He had, in fact, counted on it. Your Honor, Vera said, her voice level, I have documentation of the pre-construction drainage assessment filed by Pinnacle's own contractors, the post-flood structural inspection report from a licensed civil engineer, and a chain of written communications in which Pinnacle's representatives acknowledged the timeline of the damage in relation to the excavation's start date. Greer stared at her. A chain of written communications, he repeated. Yes, Your Honor. And you believe that constitutes a legal case? I believe it constitutes evidence, Your Honor. Which is what a legal case is made of. The silence in the room was the held breath kind. The court reporter, a young man named Theo, kept his eyes on his machine, but his fingers slowed. Two people in the gallery. A middle-aged man in paint-stained work pants. A young woman with a sleeping toddler in her lap. Watched Vera with something careful in their expressions, the look of people who had learned not to hope too much but couldn't quite stop. Greer set his pen down. Miss Odom, he said, with the weary magnanimity of a man who considers his patience a gift. I have been on this bench for 19 years. In that time, I have seen hundreds of people come in here with folders full of printouts, convinced they had found some magic combination of words that was going to win them their case. They didn't. You want to know why? Vera didn't answer. She recognized a rhetorical question designed to diminish, and she had decided before she walked into this room that she would not perform smallness for his benefit. He answered anyway. Because the law is a precision instrument. It is not a tool for people who took a weekend to read a few statutes and decided they understood it. Your mother's house flooded. That is unfortunate. It rains in Houston. It has always rained in Houston. What you have not demonstrated is causation, and without causation you don't have a case. You have a grievance. And grievances, he said, picking his pen back up, are not my department. With respect, Your Honor, the engineering report does establish causation. Vera opened her folder. The licensed structural engineer, Dr. Anita Ferreira, of Gulf Coast Civil Engineering, conducted a site assessment on November 14th and concluded, with a reasonable degree of professional certainty, that the damage pattern to the foundation and rear drainage wall is consistent with a lateral water pressure shift caused by the removal of the adjacent lot's natural grade buffer during excavation. This is not rain damage. This is construction damage, and Dr. Ferreira is prepared to testify. Foster stood up at his table. Objection, Your Honor. The plaintiff is attempting to introduce expert testimony that was not properly disclosed under the discovery schedule. It was disclosed, Vera said, without raising her voice. On October 3rd, within the court's required 30-day window. The disclosure is in the record, tab 4. Greer looked at Foster. Foster looked at his own file, flipping pages with a fraction less confidence than he'd had 30 seconds ago. Your Honor, Vera continued, I would also direct the court's attention to a documented pattern of similar incidents at two other properties adjacent to Pinnacle development sites in the last 3 years, both of which were settled quietly before trial. I have the settlement filings. She paused. Public record, tab 6. Greer's pen stopped moving. He looked at the woman across from him, at the fraying blazer and the library printouts and the careful tabs in the manila folder, and for the first time something shifted behind his eyes. Not deference. Not respect. Something closer to recalibration, the micro-adjustment of a man who has just realized the terrain is not quite what he thought it was. But Harlan Greer had not stayed on this bench for 19 years by showing recalibration on his face. Ms. Odom, he said, and now his voice had the particular coolness of authority asserting itself. I'm going to stop you right there. What you are doing, and I want you to understand this, is wasting this court's time with a document dump designed to obscure the fundamental weakness of your claim. Expert report or not, you are not an attorney. You don't know how to lay foundation. You don't know the rules of evidence. And, frankly, the spectacle of a school janitor trying to practice law in my courtroom is... Facilities coordinator, Vera said quietly. He blinked. I'm a school facilities coordinator. I manage a maintenance and operations budget of $2.4 million, oversee 14 contractors, and ensure building code compliance for a campus of 900 students. She said it, without heat, without pride. Just correction offered calmly for the record. I know what foundation damage looks like. I know what a proper site drainage assessment is supposed to contain. And I know the difference between a filing error and a deliberate procedural obstruction. Something happened in the room. It was subtle, the kind of shift you feel before you see it. The man in the paint-stained pants sat forward slightly. The young woman with the toddler lowered her phone. Greer's face had gone to the specific shade of composed that precedes a loss of composure. Are you suggesting, he said very slowly, that this court has engaged in procedural obstruction? I'm suggesting that Pinnacle Asset Solutions has. I'm suggesting that their October 18th motion to strike Dr. Ferreira's disclosure was filed knowing the disclosure was timely, and that this court's preliminary ruling granting that motion, without reviewing the original submission timestamp, may have been made on incomplete information. She looked at him steadily. I am respectfully asking the court to revisit that ruling. The room was extraordinarily quiet. Foster had stopped flipping through his file entirely. Miss Odom. Greer's voice had gone flat and very dangerous. You are standing in my courtroom with no legal training, no bar license, and no professional standing, and you are asking me to reverse my own ruling based on a tab in a manila folder. I'm asking you to look at the timestamp, Your Honor. October 3rd, 9:47 a.m. The 30-day window closed October 6th. The math is the math. I know what math is. Then you know I'm right. The silence that followed was the kind that has weight. Greer stared at her for a long moment. Then he looked at Foster. Something passed between them that was not language. A mutual recognition that the simple morning they had both anticipated was no longer the morning they were in. I'm going to take a brief recess, Greer said, and he stood before the clerk could call all rise, moving with the deliberate pace of a man who needs a moment he refuses to appear to need. He came back 11 minutes later. In those 11 minutes, Vera stood at her table and did not look at her phone. She did not review her notes. She stood with her folder closed and her hands resting on the table, and she waited, the way her mother had waited for 41 years in a house she'd earned, quietly, without apology, with the specific endurance of a person who has never had the luxury of assuming things would go her way. When Greer returned to the bench, his expression had reorganized itself into something she hadn't seen from him yet. A controlled blankness that was not the same as the contemptuous boredom of before. He sat. He opened a folder, not the one he'd come in with, a new one, thinner, that the clerk had brought him during the recess. I have reviewed the original filing timestamped for the expert disclosure, he said. October 3rd. The motion to strike was in error. He said it the way people say things they would prefer not to say, quickly, flatly, without making eye contact with anyone in particular. The motion is denied. Dr. Ferreira's report is reinstated as admissible evidence. Foster's pen rolled off the table. He didn't pick it up. Greer looked at the folder again. Then, for a reason Vera would not understand for another 4 minutes, he looked at her differently. Not warmly. Greer was not a warm man, but with a carefulness that had not been there before. Mrs. Odom, he said, before we proceed, I want to ask, and I'm asking because it has become relevant to how this court continues. What is your professional background? Beyond facilities coordination. Vera looked at him. I have a master's degree in civil engineering from Prairie View A&M, she said. I spent 11 years as a structural engineer for the Harris County Flood Control District before I moved to the school district to be closer to home when my mother's health declined. She paused. I designed drainage systems for 2 of the subdivisions adjacent to the district where Pinnacle is currently developing. I know exactly what a properly graded easement is supposed to look like, and I know exactly what it looks like when one has been destroyed. The courtroom did not gasp. That is a thing that happens in movies. What the courtroom did was go very, very still. The man in paint-stained pants exhaled slowly through his nose. Theo, the court reporter, lifted his chin a fraction of an inch. The young woman with the toddler looked at Vera and then looked away, and when she looked back, something in her face had changed. Something that had been guarded was briefly, quietly open. Foster was staring at the far wall with the expression of a man calculating how he had arrived at this particular moment. Greer set down his folder. The court, he said carefully, may have proceeded this morning on some assumptions that were not supported by the record. Yes, Vera said. It did. It was not an aggressive statement. It was not triumphant. It was the same tone she had used for every sentence that morning. Measured, specific, and without performance, which somehow made it land harder than any raised voice could have. Greer was quiet for a moment. The motion for summary judgment by the plaintiff, by Pinnacle, is denied, he said. This case will proceed to full evidentiary hearing. Dr. Ferreira's testimony will be heard. The drainage assessment comparison from the previous settlements. He glanced at Vera's folder. Tab 6, you said, will be entered into the record for review. He paused. The court will also be issuing a request to the Harris County Construction, permitting office for the original site grading plan filed by Pinnacle prior to excavation. If that plan was altered without permit amendment, This matter may be referred to the county engineer's office for independent assessment. Foster stood up. Your Honor, we would object to— Mr. Foster, Greer said. Sit down. Foster sat down. Greer looked at Vera one more time. There was something in his expression that she would think about later. Not quite regret, because Greer was not built for regret, but something adjacent to it. The expression of a man who has glimpsed, briefly and uncomfortably, the gap between who he believed himself to be and what he had actually done that morning. We'll schedule the evidentiary hearing for 60 days out, he said. Clerk will provide dates. He reached for his gavel, then stopped. Ms. Odom, your mother is fortunate to have someone who did the work. Vera looked at him for a moment. My mother did the work, she said, for 41 years. I just showed up with the paperwork. She closed her folder. She put it back in her briefcase. The battered one, the one that had belonged to her father, that still had his initials stamped faintly on the clasp. She buttoned her blazer, the good one with the fraying lapels, and she walked back down the center aisle of Division 7. The man in paint-stained pants nodded at her as she passed. She nodded back. Outside in the corridor, the fluorescent lights buzzed the same as always. The elevator smelled like industrial cleaner. The parking garage ticket machine was broken, same as it had been the last 3 times she'd been here. She sat in her car for a moment before starting it. Her phone showed 2 missed calls from her mother. She called back. How did it go? Dolores asked. Her voice was the same as it had always been, careful hope, the kind that has been disappointed enough times to wear a coat of practicality over itself. We go back in 60 days, Vera said. They have to produce the original grading plan, and our engineer gets to testify. A pause. So it's not over? No, but we're still in it, which is more than they thought we'd be. Another pause. Longer. I made your father's chicken and rice, Dolores said finally. Come eat before you go back to work. Vera started the car. She thought about Greer's face when she said she'd designed drainage systems in this county. She thought about the 11 minutes of his recess. She thought about Foster's pen rolling off the table and no one picking it up. She thought about what it costs a person to walk into a room where everything, the elevated bench, the formal language, the robes, the gavel, the architecture of it, is designed to remind you that you are small and to walk in anyway, prepared, steady, ready to do the work whether or not the room made space for it. Her mother had walked into rooms like that her whole life. Rooms that were not built for her, that had not been designed with her in mind, that expected her to be grateful for whatever scraps of fairness happened to fall. And she had endured, and she had stayed, and she had paid her house off cent by cent, and raised a daughter who knew how to read an engineering report, and knew the rules of procedure, and knew, most importantly, that knowing things is only powerful if you're willing to walk into the room and say them out loud. The drive back to the east side took 40 minutes. Vera spent most of it thinking about the 60 days ahead, the documents she'd need, the preparation, the second and third review of every exhibit. There was more work to do. There was always more work to do, but the house was still standing. Her mother was still in it, and they were still in it too. Some battles are not won in a single morning. Some are won in the deciding to show up prepared and clear-eyed, in a room that expected you to fail, and making the room reckon with the fact that you didn't.